There's nothing much because most of the submissions have been a concession. So that the question of withdrawal should not be tied to that person who has not taken plea.
No, I'm the advocate of the accused person as the parties were engaging amongst themselves. I didn't want to interrupt. I propose that let's follow the due process as both parties have argued about the bond and the review. Then when you mention the matter, we'll address the issue of the third accused person. Okay. Yeah. But the plaintiff is still in the US for medical treatment. Okay. And is supposed to be seeing a doctor on 20th of October.
But you don't have anything to show?
Yeah, that's what I was coming to. I didn't want to interrupt the proceedings. I've been unwell, and I understand there's some emails I've sent to my email. I'll go through the email and see if there's documents which I need to forward to the prosecution.
Prosecutor, you didn't say anything about the third accused.
We have not received, actually, we had an issue with the council has stated that they're going to avail documents to us. We want to trust his word.
Okay.
We just ask that the documents that are availed can be verified. Verifiable documents. The last ones we had.
They're not clear, but they'll send the clear documents.
Same terms that were given to the second accused, that's 100,000 shillings to appear. Which date, how much time, prosecutor, do you want to take the review?
Let's take a month.
1 month?
Yes, sir.
That's okay. Which date? Give me the date.
13th October.
13th of October. Is it okay with the rest?
Yes,
All right. We can mention 13th of October. That's okay with the council? It's okay.
Maybe we can push it to 23rd because I thought there's a long weekend just around that time. It's okay.
That's okay? We can have it 22nd of October. I hope the third accused will be able to attend court also.
Because it's attending a medical session on 20th of October. Yes.
All right, let's have it on that date.
Most of that.
So, Kiragu, your grant will not miss the sittings, I think?
He would.
Okay.
He will attend. I will represent all of us.
Daniel Mbidi. Daniel Mbidi. That was...
Jointly with others on the forecourt hold a certain document, namely sale agreement, purporting to be genuine and valid sales agreement signed by Julius Kitonga, a fact to be false. Is it or not true? Not true. Third count, obtaining registration of land by force pretenses, quarter section 320 of the Penal Code. The particulars are all on the 4th and 6th March 2020 at Thika District Land Registry within Kiambu County, in the Republic of Kenya, with intent to defraud and without color or right, falsely obtained registration of land parcel number Ruiru East Juja East, Block 2/36, measuring 1.310 acres, valued at Kenya shillings 10. The property of Julius Kitonga. Is it or not true? Not true. The first count is uttering a false document called section 353 of the Penal Code. The particulars are on or before 26 March 2020, 36, measuring 1.310 acres, valued at Kenya shillings 10 million. The property of Julius Kitonga. Is it or not true? Not true.
Okay. Not guilty, you know the 4 counts. Next.
We may not be taking further proceedings with regard to the hearing of the matter. So therefore, we may ease the work of the court through that settlement. On 2nd of September 2025, the said settlement was filed in the court file. 2nd of September 2025, that settlement was availed to court under the cover of a letter dated 1st September 2025. importantly also, the complainant and all what is pending is just the directions from the office of the ODPP.
Okay.
So between the complainant and the accused person, there is no dispute. On account of that, Your Honor, person, I would therefore urge you to release him on free bond. If Your Honor, before you at length, with regard to the second accused person before, and therefore, if that would be an option to you, Your Honor, for uniformity, and for the reasons that you gave last time, you consider that as reasonable cash bail, that is in the event that you do not release him on free bond. He is not a flight risk at all. And even without formal summons or warrants, he has availed himself before you. He is also a sitting member of the National Assembly, which position he would lose if he fails to attend Parliament for 8 consecutive sessions. Therefore, he is available by all means. And there is no incentive that will lure him to fail to attend court compared to losing his position as a member of the National Assembly. You notice that, just to go back to the issue of settlement, you realize that it's very substantial. The entire amount has already been paid and everything is settled. So really, there is no dispute. So kindly release him on free bond, as we come just for one mention, perhaps, to just come and have the matter settled. His case being closed, there is no incentive for him not to attend court, to come and have his the case against him withdrawn. And that's all you know. Juja constituency, which is just here after a long period, even before Pika, very near.
Is he a member of parliament?
Yes, he is.
That's where you come from also?
Yes, also Magneto is one of his constituents. I think also, Nora, you confirm, he's also the MP to the prosecutor. He represents all of us.
Who is there now?
He represents all of us.
Okay. All right, the business remains. What's your...
I appreciate that he's a member of Parliament. I will respond to the issue of the vacation of the council to have his client released on free bond. We are not opposed to him being released on lenient bond terms or cash bail. As he had rightly stated, the second accused person, who has since taken plea and is a normal citizen, was released on a cash bail of 100,000. Just to be clear on what my colleague, his submissions, that there is no dispute. Indeed, there was a dispute that led to these instant charges being registered before this court. The settlement that has been alluded to was filed in court on the 2nd of September 2025.
Yes.
If you look at the particulars in count number 1, this is a dispute that started way back in the year 2020. So let's be clear, there was, or indeed there is a dispute that resulted in these instant charges. The first time we came to this court for plea taking was on the 24th of June 2025. The dispute in question still existed. So let it be clear, these charges were brought as a result of a complaint filed by the complainants as confirmed. I have seen the letter written to the office of the DPP requesting a review of the charges against the accused persons. We will undertake the process of review and report back to this court on the outcome. We have no problem, and actually there is a legal basis for complainants to settle matters with accused persons. But our take is that once charges are preferred, then the review process must be undertaken in a fair and just manner. So now my suggestion would be we take a mentioned date. We would also have to deal with the issue of the intended third accused person who was not taken plea. Can I kindly allow us to undertake the review and not assume that because the complainant has been paid, then it is an automatic process. That the next time that we will be here, then it is automatic that it will be withdrawal of charges. We are not saying that will not happen. But let us wait for the review process to be undertaken, so that we then do not create an impression that indeed there was no dispute. There was a dispute.
Okay. Anything else?
That is all.